So, Yamina, here's another question from a viewer who is asking that as an LMIA closed work permit holder facing mistreatment, so can I switch to a new employer without an LMIA but in the same NOC under the new policy? Also, what are my options without proof of abuse or a lawyer?
So generally in this situation, we do opt for the vulnerable worker open work permit, which is a 1 year open work permit available to folks who are in Canada and are being abused by their employer. One thing that I will mention for this type of work permit is the bar for the evidence that is required is quite low. There is an assumption that the worker is telling the truth. For example, I have used text messages from the employer. I have used WhatsApp messages from the employer. I have used an affidavit or statutory declaration from the worker describing the abuse. I have used bank statements showing that the worker is not being paid. I have used letters from their colleagues showing that the colleagues have witnessed the abuse the worker is experiencing. So, as much as clients think that there is no evidence of the abuse, when you are being abused, normally there is a mark that is left. And it is part of my job as a lawyer to find the evidence, help the client find the evidence, or to create the evidence through a sworn declaration. And generally, in this situation, we would recommend a vulnerable worker open work permit. It is the easiest work permit to get in this fact scenario.
All right. Thank you so much, Yamina, for your insightful answer.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI Support, virtual immigration paralegals trained in real case prep, DocketWise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMI Support.